One DP. Present in the virtual courtroom, we have both parties as well as attorney Michelle Smith-Lowe on behalf of the prosecuting attorney's office. This is Mr. Williams' objection to the referee recommended order denying his request to set aside the default judgment in this matter. And Mr. Williams, I have read your motion. Is there any, and the transcript, is there anything else you would like to say?
No, not for real.
Okay.
It was just well, I don't know. It's too much actually. I told Sarah that well, first I was like, I didn't have well, she knew I wasn't living in town. She knew that, and I've told her that, and she knew. And then yeah, I don't know.
All right, Ms. Smith-Lowe.
Your Honor, if the court would indulge me, I made a complete record during our last hearing with Mr. Williams, but I would like to make a complete record again so that the court is aware, if the court would indulge me. It's quite a bit. As the court is aware, this complaint was filed on or about September 12, 2022. We had postal verifications of the address that, and then we all on September 27th, and then September 28th, we had another postal verification for my address. But consistently since then, including September 30th, 2022, October 4th, 2022, we had postal verifications for the address at where Mr. Williams was served. He was served by certified mail on October 17, 2022, and that was not claimed. It was not picked up. On November 18th, 2022 and November 10th, 2022, service attempts were made at that address and cards were left. We motioned the court for alternative service on November 21st of 2022 and received an order to serve alternatively. The tacking was performed on November 30th, 2022 and attached firmly to the door. The mail that was sent was returned after being soaked and resent. And then there was a handwritten note on that returned to sender that looked like Mr. Williams' handwriting. On December 1st, 2022, we received another postal verification for that address. And on December 5th, 2022, Accurate for law enforcement had him at that address. And additionally, Secretary of State showed his license at that address. Now, Mr. Williams indicates that he never had a license at that address, but I'm looking right now at a license information that states that he did have a license at that address at that time. On December 14, 2022, another postal verification for that address, as well as a Marcoux address. Because there was no answer to the complaint on January 27th, the default was returned and sent to the Marcoux address, but not returned. Again, the tacked document was not returned. We believe that if he did not receive, because if he's stating that he did not receive it, it's because he did not accept it. He indicated on the record on January 5th that address was the address of his girlfriend. He or his girlfriend didn't accept service. And even after our case ended and the default was filed, our records from friend of the court indicated that they had postal verifications on March 21st, 2023, May 30th, 2023, and August 15, 2023 at the address. He indicated in July to friend of the court that he received letters, a letter that he missed a court hearing in April, but that letter was sent to the Pine Drive address. Your Honor, we believe that service was proper. we believe that service was proper. Accurate actually still has him at that address. And we've made various ways of serving him that were calculated for him to receive proper service. He did not avail himself to participate in this in the child support process. So we believe that the default should not be set aside. However, Your Honor, again, as I stated in our last hearing, this is paternity. We want to get it right. We have no objection if the court is inclined to allow Mr. Williams to do a paternity test. We have no objection to that, and we can actually do that here in our office. Obviously, if the court is aware at a reasonable rate. And also, obviously, if he is not working, which his second motion indicates, we have no objection to friend of the court doing some type of review of income regarding what child support should be.
All right. Well, as I said, I've reviewed the record as well as the transcript, the motion, and the response. I do not believe that there's good cause to set aside the default judgment. I think at the very least, based on statements and evidence that was presented at that referee hearing, that even if Mr. Williams never received or accepted the notice that was provided under the court rule, which it was provided appropriately, and again, more than reasonable efforts were made to provide appropriate notice, that he had actual notice of this proceeding. So I will again deny the motion to set aside the default. I will order that the parties participate in DNA testing through the prosecutor's office. And as far as the motion regarding a modification of support, I'll refer that to the front of the court for an investigation and recommendation.
Your Honor, may I ask a question regarding DNA testing? Did you want to give Mr. Williams a time frame to get that done?
Yes, within the next 30 days.
30 days from today's date?
Yes.
Okay.
And
that can
Martinez,
be done here in our office.
yes.
Okay.
And Ms. Martinez is ordered to comply and make the child available as well for the testing.
Okay.
All right. Thank you. President
Thank
of the
you,
virtual
Your Honor.
courtroom, we
We're
have the plaintiff, Mr. Hanselman, along with Mr. Cox representing him. We have the defendant, Ms. Hanselman, represented by Mr. Midgorden, sorry. And we are here on the plaintiff's motion for temporary relief. Mr. Cox.
Thank you, Your Honor. This is our motion for temporary relief. I believe that counsel and I have indicated to the court that we agree to a mutual restraining order, that the one that I have asked for. So I think that's an agreement. We've also agreed that it would be a good idea to refer the issues of child custody, parenting time, and child support to the front of the court, Your Honor. And with that said, we just obviously have to address the issues of custody and parenting time on a temporary basis. Right now, Your Honor, just to bring the court up to speed, my client is living in the marital home by himself. My client's wife did leave the home apparently with her boyfriend and the children. So they are not in the home. He has been in there since last Thursday, Judge. So he's been in there about 8 days by himself. Okay, but not a minor child, correct? Okay, so please. All right. So anyway, as we also indicated, Your Honor, my client suffered injuries and trauma while he was serving in Iraq. He does have an ADA service animal, a miniature horse, who he's now been reunited with at the home. Your Honor, income-wise, both parties are not working. My client has not worked since 2015 because of his disability and injuries he suffered while in Iraq. But he does have a disability income that allows him to keep the finances for the household up and running. Your Honor, at this point, I'm not trying to ignore the fact that there's also a personal protection order involved. We did file an objection to that, and Adam Colmar determined that counsel and I needed to review some of the discovery before we moved on with a hearing on that. So as it stands, Your Honor, obviously the two big issues at hand here are what's going to become of custody while we're waiting for a front of the court investigation and recommendation. My client is asking the court to grant him legal and physical custody and to give the parties an appropriate parenting time arrangement while the case is pending. My suggestion to the court would be that given the children are homeschooled, and my client does have some concerns about that, and the fact that my client has been the homeschooler or stay-at-home dad, if you will, for a while, he has concerns about mom making efforts to really do anything with respect to homeschool. So we'd ask the court to consider, again, that my client be awarded temporary legal custody, temporary physical custody, and that a parenting time of week on, week off be implemented while we're waiting for the front of the court to chime in. Thank you.
All right, thank you. Mr. Midgorden.
Yes, Your Honor, just to respond. So first of all, Mr. Wilson, the person that the plaintiff is referring to is actually gay. He's a homosexual and has been out for a number of years. Second of all, on the homeschooling matter, my client, Ms. Hanselman, is actually the registered teacher with the state for the homeschooling because you have to have a bachelor's degree to do that. So with the state, she's the registered agent to homeschool the children. And likewise, as Attorney Cox did highlight, we agree that it does need to be sent to the friend of the court for investigation. But unfortunately, my client is asking for the same thing as sole legal and physical custody, as the kids have been in her care since, at least as my client alleges, that the plaintiff, was in the hospital as recently as January for an overdose on prescription drugs. And the kids have been in her care since then. I know that the order for exclusive use was granted ex parte. We did file an objection to that. Sorry, there's a prompt popping up. So yeah, that would just kind of be our stance as well, Your Honor, is that we'd be asking for sole legal and sole physical custody as well on those grounds. And second of all, just to have a parenting time put in place pending the FOC investigation.
All right, Mr. Cox, what's the response to the allegation of the hospitalization?
7 days.
Your Honor, my client voluntarily did go into the hospital. He acknowledges that he is being treated for PTSD by his therapist, Amber Schneider, who he sees 3 times per week. He is on Lametco, which is a mood stabilizer. He is on Lexapro for his anxiety, Trazodone for his sleep, and Prazosin, which controls nightmares for people who suffer from PTSD. And again, I think we could all agree when the medical reports come back, both parents suffer from a multitude of psychological problems. And I'm told by my client that he and his wife are on the 3 of the same medications, Lamictal, Trazodone, and this Prozacian, which I think my client's telling me I'm mispronouncing. And she is apparently also on Wellbutrin. But I think the good news here is I think neither one of them avoids a need for therapy. I think they're therapy seekers, and they both stay on their meds, and there has not been a history of domestic violence or alcohol or drug abuse in the house.
All right. Again, this is a motion for a temporary order. The court obviously is having to rely on what each party is telling me. Given that, there's clearly a factual dispute here, but I will enter a temporary order that grants the parties joint physical custody. Even the plaintiff was asking for week on, week off, so that's what I will do. Joint legal custody, so that both parents have to be involved in any major decisions. In this case, I will maintain my order for exclusive use that I entered ex parte for Mr. Hanselman, given the support animal that's involved here. I heard an agreement regarding the mutual restraining order. Is there anything else I need to resolve?
I think that's it, Your Honor. Oh, did you want the parties to pay equally for the investigation fee?
Oh, right. Referral to the front of the court. Yes, 50-50 on the fee. Anything else, Mr. Midgorden?
Yes, Your Honor. I guess the question then would be, since it's 50-50, when should defendant's parenting time begin? Would that be this weekend or next weekend? When would we start that? Just to make sure there's no confusion.
If we could start this weekend, that would be great. And I think if counsel agrees, I think Sunday to Sunday is always the easiest transfer date. I think that would be acceptable. Would be Sunday at 5 is the exchange.
That would generally be my recommendation as well, Attorney Cox, but I would verify with my client to make sure there's no conflict there. Ms. Hanselman, would that be okay, Sunday 5 to 5?
It would, thank you.
Thank
All
you.
right, great.
Did
Anything further?
he start this Sunday, Your Honor?
Yes.
Okay, thank you.
Anything
I'll prepare
further?
the order. I'll prepare the order, Judge. Thank you.
All right, thank you.
Thank you, Your Honor.
We're adjourned. Present in the
Thank you.
virtual courtroom, we have both parties as well as Ms. Canfield Kuiper representing the defendant, Mr. Smith. This is the time and place noticed out for a divorce trial in this matter, and it's my understanding that the parties have reached a resolution of all the issues in the matter. Is that correct, Ms. Canfield?
Yes, it is correct, Your Honor. Ms. Smith and myself were able to communicate throughout the week, and we've come to an agreement on all outstanding issues. And I would ask that the court allow me to place those settlement terms on the record and
Please
then
do.
proofs.
Go ahead.
Thank you so much. So bear with me, this is kind of long. We went back and forth on several things. So Ms. Smith, listen carefully and correct me later if I've forgotten anything, okay?
Okay.
To Mr. Smith. All right, so we have agreed that the friend of the court recommendation regarding joint legal custody and joint physical custody will be in effect as the final order for custody and parenting time with a couple tweaks. The exchanges, instead of being on Friday, will be on Sunday evenings at 6 p.m. They will occur at the D&W. The parenting time, as I said, will be per the friend of the court recommendation, inclusive of the holidays therein. Child support would be pursuant to the Michigan child support formula based on the 50-50 parenting time and income of the parties. The extracurricular and school events for the children will be agreed upon in writing and thereafter shared 50-50 in cost by the parties. There is a specific provision for travel out of the state, which I will now hopefully read if I can locate it. For the children's events that require out-of-state travel, the defendant will pay $75 a night for the camps and hotel rooms that he cannot attend. He will include the night before the competition and will not pay for extra days stayed beyond the conclusion of the event. The defendant will share 50-50 in the costs of gasoline to transport the child to the competition and for the hotel, only in the event that he is unable to attend. If the defendant does attend the out-of-state events, he will cover his own expenses and will not contribute to costs, as the child may travel and stay with him on those occasions. Regarding the tax returns, the parties will file their 2023 tax returns married, filing separately. The defendant will claim the children for 2023 and all subsequent odd tax years. The plaintiff will claim the children for 2024 and all subsequent even tax years. The parties share discovery vacations and a Florida timeshare. The discovery vacations will be awarded to the plaintiff and all costs associated therewith. She will hold the defendant harmless. The defendant will be awarded the Florida timeshare and all costs associated therewith and will hold the plaintiff harmless. There are 5 shares of the company Premier Botanics. The plaintiff will be awarded 2 of those shares. The defendant will be awarded 3 shares. The defendant will notify the company personnel of plaintiff's shareholder status so that she may start receiving her new shareholder welcome package and financial reports on those shares. The parties will agree to each keep their own vehicles and any debt associated therewith. They will agree to exchange any titles or as necessary to effectuate that award. The individuals have separated their bank accounts and each will keep their own bank accounts with no equalization. The German shepherds that are pets of the family will be awarded to the defendant, who will assume the cost of veterinary care, food, shelter, and grooming for the dogs. Spousal support is not awarded to either party. It shall be waived by both parties and forever barred under Staple versus Staples, except for as necessary to enforce any debts that may be owed under this judgment of divorce. I'm just checking to make sure. The personal property that is in the marital home, Your Honor, will be awarded to the defendant. The marital home will also be awarded to the defendant with no equalization or equity to the plaintiff for the following reasons. There is approximately $118,000 of debt on the house, and there is a 48% unlock loan on the home that came about during COVID, which would require that 48% of any home sale to be paid back to unlock on top of the mortgage debt. It is only appraised at $330,000. The defendant would only then be entitled to pay the plaintiff $26,800. However, the defendant is going to assume his individual debt as well as the marital credit card debt, which equals approximately $60,000. So half of that debt that would have been plaintiff is actually more than what her equity that she would receive from the home would be. So they fairly balance out. So he is assuming all of that joint marital debt. Any individual debt assumed by the parties after separation on September 1st of 2022 will be their own individual debt. I believe I have covered everything. Mr. Smith, did I miss anything that you and I discussed?
I do not, I do not believe so.
Ms. Smith, is this the agreement that you and I had come to in negotiations for this?
The only question I have is about the credit card debt, where you said his individual and marital. I know I responded back to make sure that like our individuals before October 1st or September 1st, 2020, that all of our credit cards, because we both shared into it, whether it's just in my name or his name, was going to be covered.
Yes, Ms. Smith, and that's the way that the judgment will read, is that will be considered joint marital debt if you both were utilizing those cards prior to separation.
Okay,
Right?
perfect. Yep,
All right.
then
Did I miss anything else?
nope, you're great. Thank you.
All right. Your Honor, with the court's consent, I would be happy to take proofs from either Ms. Smith or my client.
All right. Was there a cross complaint for divorce filed by your client, Ms. Canfield?
I don't believe so. I think we just filed an answer.
Ms. Smith, are you okay with Ms. Canfield asking you the statutory questions
Yeah.
that are required? They're pretty simple. Ms. Canfield.
Thank you. Ms. Smith, were you lawfully married to my client Sean Smith by someone able to perform marriages?
Yes.
And what year did you get married?
2005.
All right. And at some point in time in the year of 2022, did you file a complaint for divorce?
23, I did.
2023. Thank you, ma'am. And at the time that you filed that complaint for divorce, had you been residing in the state of Michigan and the county of Kent for over 180 days?
Yes.
And you alleged in that complaint for divorce that there had been a breakdown in the bonds of matrimony to the extent that there's no reasonable likelihood that they could be preserved. Is that accurate?
Yes.
You also had children of the marriage. How many children did you have?
We have 4.
All right. One is adult now, is my understanding.
Yep.
So 3 minor children remain.
Yes.
And are you currently pregnant?
No.
Okay. You have heard, are either of you in the military currently?
No.
All right, thank you. So you have heard the agreement as we stated it on the record previously. Is that correct, ma'am?
Yes.
Did you have time to negotiate those terms with me and to consult someone else about any questions you may have regarding them?
Yes.
And did I make it clear to you that I represented Mr. Smith and not yourself?
Yes.
All right. And do you understand all the terms and conditions that have been placed on the record?
Yes.
With respect to those terms regarding the custody, parenting time, and child support for your minor children, do you believe that those terms are fair and in the best interest of the children?
Yes.
And with respect to the division of the assets and debts that were accumulated during your marriage, do you believe that those terms are fair and equitable as they've been stated on the record?
Yes.
And do you understand, ma'am, that there would have been an opportunity for us, and it was scheduled today, for you to go forward with a trial for divorce, where Judge McNabb may decide things differently than what you agreed upon?
Yes.
Are you willing to waive your trial and have the judge enter a judgment of divorce once we draft it that is consistent with the agreement we've reached today and placed on the record?
Yes.
All right. And have you done your agreement willingly and voluntarily in this matter?
Yes.
Do you have any questions about the terms other than what we've previously clarified?
No.
All right. And Your Honor, if I may, I have no further questions for Ms. Smith, but I'd just like to go over the terms with my client.
All right, before you do that, I just have one question. Ms. Smith, if I told you that the records show that you filed the complaint for divorce on March 3rd, 2023, does that sound right?
Yes.
Okay, wonderful. Thank you. Go ahead, Ms. Canfield.
Thank you, Your Honor. Mr. Smith, you've heard all of the terms and conditions for your divorce settlement placed on the record. Is that true?
Yes,
Do you have any questions about any of those terms?
I do not.
Did you have enough time to adequately go over and discuss those terms with myself?
Yes,
And are those what you have agreed to knowingly and voluntarily today?
yes,
And to you, I pose the question as well. You had the opportunity to go to a divorce trial today where Judge McNabb may decide the facts and the circumstances and the decision regarding your children and debts and assets. Is that true?
yes,
And do you agree to waive your right to trial today to enter the agreement that you've reached with Nova Smith?
yes,
And are you doing so voluntarily and knowingly?
yes, I am.
Has anybody forced or promised you anything in order to get you to enter into this judgment of divorce?
No,
Do you, sir, agree as well that the terms regarding custody, parenting time, and child support are in the best interests of your minor children?
yes,
And do you think that the terms that you've reached regarding division of the assets and debts of your marriage are fair and equitable?
yes, I do.
I have no further questions, Your Honor.
All right, thank you. The court finds that the proofs are sufficient, that the proposed custody, parenting time, and child support terms are in the best interest of the children, and that the property division appears to be equitable. And the court orders that a judgment of divorce, a consent judgment of divorce, be provided to the court electronically within 21 days from today.
Absolutely, Your Honor. We're already beginning to draft it.
All right, is there anything further?
Nothing further.
All right, best wishes to both of you.
Thank you.
Thank you.
Thank you so much, Your Honor. Have a good weekend, everyone.